Hello, good evening, and welcome to Unacademy, a one-stop destination for the English medium civil services aspirants. Welcome to UCAN, and in this session, we shall discuss important polity-related articles which were in the news during the period 27th November to the 9th of December. Let's get started, but first up, an important announcement. You may be aware that on the 10th of December this year, Unacademy celebrated its 9 years of existence. And to commemorate the 9 years of continued success, the Unacademy group decided to offer something to the students, something special. If you enroll in UPSC courses for 9 months, you will get 9 months subscription free extension on the 9-month subscription that you buy. Similarly, for 12 months, 18 months, basically, if you buy subscription for 12 months, 18 months, you will get it further extended by the same period. And this is something that has been communicated to you for a long time now. But this offer, I'm told, ends on the December 23rd. But listen to me carefully. Whether you should join coaching or not, please don't ask anybody. And don't ask me either, because I'm going to say yes. Ask this question to yourself. Do you need it or not? There are advantages, but there are also costs involved. If you can afford subscription, please go ahead. Otherwise, you can prepare on your own as well. But listen to me carefully. Yesterday, I was interacting with a group of 35 to 40 students, and majority of them were from my previous institute, and they needed guidance. And this is where we realized that those students who have been left behind, if you need guidance further, you can please reach out to us at any point in time, and we are happy to help you. Similarly, for those who will opt for the UPSC subscription, if you use this code IAS English, then all the teachers on your screen, they will be providing you one free mentorship session. This is something not provided by Unacademy group. This is something provided by your English team. So if you're enrolling before 23rd of December using this code IAS English, the backend team will communicate to us that these are the students who are looking for guidance, mentorship from the IAS English team. That's something that I wanted to communicate at the start. Now let's look at the topics that we are going to discuss today. You would know that 26th of November every year since 2015 is celebrated as the Constitution Day. And around the same theme, lots and lots of beautiful articles were written in the Indian Express, and we will pick up some of these articles relevant for the Civil Services exam. The first one, written by former Chief Election Commissioner, Dr. S.Y. Qureshi. He talks about Election Commission, the need for democratic and electoral reform. The second, we will have a face-off between Sai Deepak and Faizan Mustafa. One of them is arguing that our constitution is at odds with the civilization. Faizan Mustafa disagrees. We will understand the nuances of these arguments. This article has been picked from the Indian Express. Then we will look at the Supreme Court order on Sambhal and also look at the Places of the Worship Act 1991, although we have covered that in our previous UCAN session as well. But there is an update, and that update I will be sharing today. Is the caste census a useful exercise? This article has been picked from the Hindu. Do new schemes ahead of elections amount to voter bribes? This article also has been picked from the Hindu. And the last one, women vote bank. Is it a reality or an optical illusion? And this is something that I have picked from the Frontline. Very important article, can be relevant for GS paper 1 as well. Let's dive into all these articles one by one. And first up, let's look at The Greatest Show Must Go On, written by Dr. S.Y. Qureshi, as I told you, former Chief Election Commissioner. On the 9th of December, 1946, Constituent Assembly met for the first time to draft the Constitution for the independent India. And for the next 2 years, to be precise, 2 years, 11 months and 17 days, the Constituent Assembly worked very hard to draft the Constitution of the independent India. Obviously, this Constitution had a lot of influence from other countries. For example, Canada, for example, Australia, United States, Germany, Russia, USSR, United Kingdom. But this Constitution has a unique Indian identity as well. And that is how this Constitution even begins with, we the people of India. And we deliberately chose what? Constituent Assembly chose parliamentary democracy and not presidential form of government. The question that you need to ask is, why did the Constituent Assembly opt and adopt a parliamentary form of government and not a presidential form of government? Because the presidential form of government is viewed in terms of stability. For example, the President of the United States of America will complete his term of 4 years, even if the party to which he belongs does not have the majority in the Congress, does not have the majority in the House of Representatives or the Senate. So, unique feature of a presidential form of government is that it is stable. You can impeach the president, you can convict the president, but not because the president's political party does not have the majority on the floor of the legislature, but only if the president commits treason, the highest offense against the state. But the Indian Constituent Assembly opted for a parliamentary form of government. Why? Because we chose accountability over stability. Although, as I told you, that presidential form of government is viewed in terms of stability, it's considered to be stable form of government as compared to parliamentary form of government. But in parliamentary form of government, the very essence is accountability. The Council of Ministers are collectively accountable to, responsible to the lower house of the Indian Parliament, which is the Lok Sabha. So the Constituent Assembly opted for parliamentary form of government because we prioritized accountability over stability. Also because in presidential form of government, there is concentration of power in the executive. There is less accountability of executive to the legislature. And at the same time, India is a diverse country. And to represent the interest of this diversity, we opted for a parliamentary form of democracy. But if we adopted a parliamentary form of democracy, to ensure this democracy, the most important provision has to be the organization of free and fair elections. Now, what do we mean by free and fair elections? Free in the sense, anybody who is eligible to contest elections should be able to contest. Anybody who is eligible to cast vote should be able to exercise his or her right to vote. Anybody who wants to establish a political party should be allowed to do that. But then these elections should also be fair. Fair in the sense that we should not have a situation where the government machinery will be biased in favor of the ruling political party. The entire election mechanism has to be such that it does not favor one political party over the other. That means the voting system, how the votes are counted, how fairly the results are declared, all that is an integral part of free and fair elections. And the Supreme Court has said it is this free and fair election which is part of the basic structure of Indian Constitution. And to ensure that elections are free and fair, Constitution provides for, under Article 324, an independent constitutional entity called the Election Commission of India. And Constitution says superintendence, direction, conduct, control of all elections, whether it is election to the office of President, Vice President, election to the state legislative assemblies or councils, election to Lok Sabha or the Rajya Sabha, all these elections, to conduct them, to ensure free and fair election, is vested in this constitutional body called Election Commission of India. In fact, Constitution further provides for Article 329, which you would know bars the interference of courts in electoral matters. Because during the election process, if there is interference by courts, then the election process would get derailed, and ultimately you will not be in a position to hold the political class accountable. That is why if you're not happy with this election process, you can file the petition after the election is over, but the courts are prohibited from interfering in the electoral matters. Is our constitution federal? Yes. Who says this? Dr. Ambedkar said ours is the federal constitution, despite the fact that he has used the term Union of States in Article 1. And the court has said, Supreme Court has said in SR Bombay versus Union of India, that federalism is part of the basic structure of Indian constitution. But even if we are a federal polity, there are some features which are biased in favor of the union. That is what we call centralizing tendency of Indian federalism. One such feature which can convince us that our constitution favors a strong center is the centralized election machinery called Election Commission of India. Because the Constituent Assembly debated who should be given the power to organize these elections at the state level. Should we give this power to a state authority, or should we give this power to a central authority? Constitution provided for a central authority. That is why we have an Election Commission of India to organize elections at the center as well as at the state level. Why? Because Dr. Ambedkar argued in the Constituent Assembly that if we give this power to the states, what states will do, they will prejudice. That if you are racially from our state, linguistically from our state, culturally from our state, we will allow only you to contest elections from our state. Then what will happen to the preambular objective, which is fraternity, which is one of the objectives of the Constitution mentioned in the preamble? That is why Dr. Ambedkar argued in the Constituent Assembly that no person who is entitled should be excluded merely as a result of the prejudice of the local government. That is why this entire election process is concentrated at the hand of the center. There is a Central Election Commission of India. This is one of the centralizing tendency of Indian federalism. But listen to me carefully. How have we performed electorally? How is the election conducted in India? Is it fair or not? For that, Dr. S.Y. Qureshi cites the examples. For example, the accolades from across the world, from United States, Hillary Clinton, wherein she says that Indian elections is the gold standard of fairness. Where New York Times has said that the Indian elections is the greatest show on earth. Fortunately or unfortunately, we need validation from the Goras, from the European and the West, whether we are good or bad. But keeping that aside, our elections have been conducted periodically, regularly over a period of 5 years. And for years and years, our election process has been considered as the most fair election process in India. But Dr. S.Y. Qureshi argues that despite the fact that elections are conducted well and fairly in India, that does not mean that we are a great democracy. Because there are still problems. There are some indices, global indices, which call India electoral autocracy. Despite elections, the government is autocratic. Their views, not mine. So don't lynch me for this. There are some who call Indian democracy as a flawed democracy, despite the fact that elections are conducted on a regular basis and conducted very fairly. Which means it calls for electoral reform. That is why there is a need for urgent reform, and that is the mandate of this article. And Dr. S.Y. Qureshi writes that the greatest blessing of our electoral system is the activism played by our Supreme Court. Because Supreme Court, through its various judgments, it has carried out various electoral reforms. Various electoral reforms. For example, this year in 2024, the Supreme Court, a constitution bench of the Supreme Court, struck down electoral bond scheme. Why? Because the Supreme Court said this electoral bond scheme is manifestly arbitrary. And if it is arbitrary, it violates Article 14 of the Constitution. Why arbitrary? Because prior to electoral bond scheme, only those profit-making entities could have donated money to political parties. Now, because of the changes made, not just because of electoral bonds, but because there were changes made to the income tax laws, to the corporate governance as well. Because of those changes, now even loss-making companies could have donated money to political parties. There was a limit. A corporate entity could have donated 7.5% of the profits over the past 3 years to political parties. Now this limit was eradicated, removed. That means you can donate any amount of profit to the political parties. And if you're donating money to political parties, there is always quid pro quo. You always expect something in return, maybe a tender, maybe a contract, maybe tweaking of the rules that will help the business, which makes this scheme manifestly arbitrary. And it also violates the citizen's right to know, which is a fundamental right under Article 19(1)(a) of the Constitution. Because you have the right to know who is donating what to a political party so that you can make an informed choice, so that you can decide whether you want to vote for a political party or not. That was thanks to the Supreme Court. Thanks to the Supreme Court, we have a judgment where Supreme Court directed the Election Commission of India that you should provide one more option to the voter, which is none of the above. If you're not happy, satisfied with the candidates put up by the political parties, you don't want to vote for any of them, press nota on the electronic voting machine. Although it calls for reform. Because over a period of time, we see the number of votes polled in favor of nota has dwindled. That is why some constitutional experts say, instead of nota, it should have been not be. Which means instead of none of the above, it should be none of the below. Which means instead of the last option on the electronic voting machine, it should be the first option on the electronic voting machine. That would make it convenient for voters to press the first button. It is because of Supreme Court that Supreme Court decided that free and fair election is part of the basic structure of the Indian Constitution. This was way back in 2003 in People's Union for Civil Liberties case. So thanks to the Supreme Court, lots and lots of electoral reforms have been carried out. And let's not forget, it was the Supreme Court which directed the political parties that if you are giving tickets to candidates with criminal past, you mention it prominently on your website. You mention it prominently in at least 2 newspapers. Why you are giving tickets to candidates with the criminal past. And you should not say we are giving them tickets because they are winnable, because they have the winnability factor, because they will be able to win the election. You have to tell us the precise reason why. So Supreme Court, through its judgments, have played a very important role in ensuring that there are reforms carried out in our electoral process. But even then, something more needs to be done. According to S.Y. Qureshi, when we started our journey of constitutional republic, there was low participation of women, both in terms of voter enrollment and voter turnout. That means women would not be enrolled as voters as compared to men, as much as men. And at the time of the elections, women would not outnumber men when it comes to the voter turnout. But this is where Election Commission has played a very important role, a stellar role. Now, because of the awareness, because of various awareness programs, because of mass media, because of social media, because of door-to-door campaign, because of a beautiful program called SWEEP, Systematic Voter Education Program, we have seen that there was this gender gap. This gender gap used to be 10%. That means if there were 60 men voting in the elections, women would be only 50. That means there was this gap of 10% gender gap when it comes to the voter turnout. And do you know today what is this gender gap? It's almost eradicated. Equal number of women and men come out in large numbers and vote in the elections. And in fact, if you look at the recent trend, in 2024 elections, there were 19 states out of 28 states and 8 union territories. 19 such states we saw where the women voter turnout was much higher as compared to men. So if this was one problem that we faced at the time of becoming a constitutional republic, now because of the systematic programs innovated, implemented, designed, conceptualized by Election Commission of India, we have been able to bridge this gender gap when it comes to voter turnout. And in fact, in some states, women outnumber men when it comes to polling booths. But even then, when it comes to women's participation, what about women's political representation? 73rd and 74th Amendment was made. It provided that not less than 1/3 of the seats in Panchayati Raj institutions and urban local bodies shall be reserved for women. And there are some states where this political reservation for women is 50%. And now, because of the 106th Constitutional Amendment Act, there is women's reservation in Lok Sabha and the state legislative assemblies as well. Of course, it is delayed. Delayed because unless and until we conduct census, which will be followed by a delimitation exercise, which might take 2029, till 2029, maybe both these processes will be completed. So maybe in 2029 elections, we may have women's reservation finally becoming a reality in Indian politics. But even then, there are concerns. Concerns such as, there are new challenges. The use of black money in the Indian elections, criminalization of politics. And the problem with criminalization of politics is lawbreakers become lawmakers. So if you are a criminal, if you have a criminal past, yet you are allowed to contest elections. And we are not talking about those who have been convicted, because if you are convicted for a crime, you are disqualified. And for 6 years after your release, you cannot contest elections. But what about those who are accused of serious crimes? For example, rape, for example, murder, where charge sheet also has been filed. But we know the judicial system is slow, working at a snail's pace, and these lawbreakers, they exist as lawmakers. So criminalization of politics, use of black money in the Indian elections, and there is no limit to the amount of money spent by political parties. There is a limit to the amount of money spent by a candidate in the election, but there is no limit to the amount of money spent by political parties. There should be a limit, according to Dr. S.Y. Qureshi. And on top of that, should we stop, ban and bar private individuals or corporates to donate money to political parties? Should we have state funding of political parties or state funding of elections? If not state funding of elections, can we have state funding of political parties? And how do we do that? If we have something called National Election Fund. Whoever wants to contribute to this National Election Fund, it should be tax-free, so that you encourage more and more people to contribute to this fund. And from this fund, we should provide money to political parties in proportion to their vote share, which will encourage political parties to go deeper into the roots of India and convince people to vote for them. Because more vote share that you get in the elections, more money you can obtain from this National Election Fund. This is the pressing need of our times, according to Dr. S.Y. Qureshi. This is a beautiful article relevant for your UPSC mains specifically. And at the same time, Article 324, which we discussed, which provides for an Election Commission of India. How Election Commission will be constituted, in a sense, what will be the composition, how these Chief Election Commissioners and Election Commissioners be appointed. For that, Constitution envisaged that Parliament should enact a law. But till 2024, such a law was not enacted by the Parliament. And it led to the Supreme Court again. That's why you can be asked in the exam the role of the Supreme Court in electoral reforms in India. It's thanks to the Supreme Court in Anup Baranwal case, where Supreme Court said Parliament should have enacted a law. And since you have not enacted a law, till the time you enact a law, this committee consisting of the Prime Minister, Leader of the Opposition in the Lok Sabha, and the Chief Justice of India, they will come together and recommend to the President who should be the Chief Election Commissioner and the Election Commissioners. Because if the mandate of the Constitution is free and fair elections, for that the umpire, which is the Election Commission of India, also needs to be fair. And how do we ensure that this umpire is neutral and fair? It's how you appoint these individuals, so that not even an iota of doubt should remain in the minds of the people that if executive has the complete control over these appointments, this election commission body will be biased in favor of the ruling party. Although now we have a law where we will have the Prime Minister of India, Leader of the Opposition in the Lok Sabha, and the Union Minister nominated by the Prime Minister. They will be part of the committee. They will recommend names to the President who should be appointed as the Chief Election Commissioner and the Election Commission. But by the composition, by the look of it, it seems that this body, this collegium, this committee is biased in favor of the ruling political party. So it may not give sense of satisfaction to the people that this body is unbiased. The umpire is neutral. The umpire is not biased. So maybe we need time to tweak it as well. This is according to Dr. S.Y. Qureshi. And Dr. S.Y. Qureshi concludes by saying, only if we implement this can our objective, our purpose, because we are the world's largest democracy. If United States is considered to be the world's oldest democracy, we are the world's largest democracy. But if we want to convert the largest democracy on the planet to the greatest democracy, for that these reforms are required, necessary, urgent, according to Dr. S.Y. Qureshi. Let's look at some questions. India adopted a parliamentary form of government because constitution makers prioritized accountability over stability, something that we discussed at the start. It's correct. Parliamentary democracy provides for collective decision making because you have the Prime Minister, you have the Council of Ministers, collectively they take a decision. In a presidential form of democracy, government, president has all the powers are concentrated. And the third one, India is a diverse country, and to respect the diversity, we need to provide for a collective decision making, which will be the representative of the different diversities that are present in India. And that is why all the statements are correct. If you look at the mains examination in 2017, 2018, questions around this topic have been asked in the exam. Because whenever such things are in the news, related questions will be asked in the examination. For example, in 2017, to enhance the quality of democracy in India, the Election Commission of India has proposed electoral reforms in 2016. So reforms proposed in 2016, question asked in 2017. What is this? This is current affairs. What are the suggested reforms and how far are they significant to make democracy successful? And whatever reforms we were discussing, basically these were the reforms which have been suggested by Election Commission of India. that there should be a ceiling on the political parties' expenditure, that state funding of parties and not elections should take place. Because even today, Chief Election Commissioner can be removed by President. In the same manner, on the like grounds as the Judge of the Supreme Court, which means the Chief Election Commissioner has security of tenure. You cannot be removed arbitrarily. You can be removed by the President based on the resolution passed by both houses of the Parliament, that too by special majority, which is difficult to achieve. So Chief Election Commissioner has security of tenure. But what about election commissioners? Election commissioners are removed by the President on the recommendations of the CEC. So the same process of removal, which is there for CEC, is not provided for the election commissioners. And that is what Election Commission has been asking. Election Commission in its report has been asking for this reform, that there should be the same process of removal for election commissioners as well. The same process that we follow for the Chief Election Commissioner. And in fact, there should be some cooling off period. Cooling off in the sense, once your term as the Chief Election Commissioner or Election Commissioner is over, for some time you should not be allowed to join a political party, which can be 2 years, which can be 5 years, which Election Commission said should be 10 years. But we have seen instances where one election commissioner, his term got over, Mr. Gill, and then he was sent to Rajya Sabha by the Congress party. So there has to be cooling off period. All these reforms are important. Another question, because as soon as elections are over and a political party loses the election, instead of blaming itself, its ideology, its leadership capabilities, you start blaming the electronic voting machines, because you divert the attention. And this is where some opposition parties have also criticized the Congress that you should go beyond criticizing the electronic voting machines. And there have been some voices within the Congress party as well. For example, Mr. Karti Chidambaram, who is the member of parliament in Lok Sabha from Sivaganga constituency in Tamil Nadu. He said that I am yet to see any issue with electronic voting machine. So elections, loss in the elections, blame on the EVMs. This has been a recurring topic in current affairs. And this was asked in 2018 in light of the recent controversy regarding the use of electronic voting machines. What are the challenges before the Election Commission of India to ensure trustworthiness of elections in India? So look at all these current affairs topics thoroughly, both from prelims and mains perspective. And that is where the role of the PYQs becomes very important. Because previous year's question papers will tell you how to study for this examination. Clear? That's about topic number 1. Let's look at topic number 2. Constitution is not at ease with civilization. Argument put forward by Sai Deepak. Faizan Mustafa says, it looks forward, Constitution looks forward, but it is still rooted in civilization. Let's look at both these arguments together. Fantastic arguments by both these individuals. And this is a very important topic for your mains examination. Let's look at first the arguments of Sai Deepak. His argument is, and in fact, there were some who were not satisfied with the Constitution. For example, Mr. P.V. Kane. He writes in the History of Dharm Shastras, Volume 5. He criticized Indian Constitution on the ground that Indian Constitution is blindly aping the West. Because Western liberal constitutions, they focus on the rights that citizens should enjoy. But what about the duties that citizens should have towards the state, towards the fellow human beings, towards the environment, towards the living creatures? Those duties are absent in the Constitution. And we are talking about the Constitution of 1950, because fundamental duties were added later through a constitutional amendment, 42nd Constitutional Amendment 1976. So there were people who were not happy, satisfied with the constitution. In fact, RSS for a long time, it criticized the Indian constitution, saying it is not rooted in India's cultural ethos and civilization. Some critics argue that RSS would not be celebrating, would not be hoisting the national flag. Instead, they would hoist their own flag. So there have been arguments right from the time constitution was enacted, saying it is not in agreement with our cultural ethos. And primarily, they criticize it on the grounds that our constitution believes in something called constitutional morality, which we will discuss today. J. Sai Deepak argues that in 1947, when India liberated itself, when we decolonized ourselves, we were a colony, independence decolonized us. Yet after the independence, although we have got political independence, political decolonization has taken place, but we are still not able to decolonize the Indian psyche, the Bharatiya psyche. The consciousness of people is still colonized because we are yet to come out of the consciousness which has been imposed by the British and after that by the Constitution of India, which is at variance with the cultural ethos of India. The net result, according to J. Sai Deepak, is British made effort to give its own vision of democracy to Indians. And this vision of governance was very different from our culture, from our civilization. J. Sai Deepak argues that the damage which British did has been less than the damage Indian independence did to our culture, because this constitution has further cut us, severed us from our civilization. Why? He is particularly against this notion of constitutional morality. And what is this constitutional morality? Something which was propounded in the Constituent Assembly by Dr. Ambedkar, although it is not his concept, it's the concept which has originated in the West. But what is this constitutional morality? For example, Section 377 of the Indian Penal Code, which spoke of unnatural offences against the order of nature. And this Section 377, long story short, criminalized homosexuality, saying homosexuality is a crime, and if you indulge in it, you are a criminal. In fact, matter went to the court. In Delhi High Court, the Delhi High Court said Section 377 is unconstitutional. But when it was challenged in the Supreme Court, in the Koshal case, Supreme Court upheld the validity of Section 377 on the grounds that if this law has been misused, that's the problem of the police, not the courts. If Indian Penal Code since independence has been amended more than 30 times and the Parliament did not deem it fit to amend Section 377, so that's the problem of the Parliament. So basically, Supreme Court put the ball in the court of the Parliament. If Parliament wanted to amend Section 377, they could have done that. Since they haven't, we will have to abide by it. And Supreme Court further said that for a minuscule minority, we should not be tweaking our laws. Basically, the court said members of the LGBTQ community, they form a minuscule minority. But finally, the matter went to the court again. Navte Johar versus Union of India. Supreme Court said Section 377 is read down. It's not unconstitutional, it has been read down. Why not unconstitutional? Because there are still some unnatural offenses which were still a crime. For example, bestiality, incest, that was still unnatural, against the order of nature, as such would come under Section 377. Bestiality in the sense, sex with animals. is a crime, was a crime under Section 377 even after Navte Johar judgment. Navte Johar judgment only decriminalized homosexuality. Read down Section 377 to say that homosexuality is no longer a crime. And in giving this judgment, the court relied on constitutional morality. What is moral to you is immoral to me. What is immoral to me is moral to you, and vice versa. So how should we define the morality? It keeps on changing. It keeps on evolving over a period of time. The example that I give in the class, for example, there was a time when a romantic scene or an erotic scene was to be displayed in a movie in 50s, 60s. It was done by the kissing of the flowers, because full-blown kissing scenes would have been considered immoral according to the then contemporary standards of morality. But right now, that's not the case. So we see erotic scenes in the movie. So what sort of morality should we focus upon? Something that is our individual morality, or the morality of the majority? Whether majority believes in a particular religion or a particular caste or a particular linguistic group? Or should we believe in some principles which are ingrained into the Constitution? Into the Constitution, for example, should we look at every issue from the perspective of rule of law, from the issue of liberty, equality, justice? It would be violating liberty, equality, justice if you deny LGBTQ community their fundamental right to love. So do we have to look at this issue from the perspective of the morality of the society, even if it's the majority, or the morality which is enshrined in the Constitution, which believes not in the morality of religions or majority, but morality which is deeply ingrained into the constitutional philosophy, which is constitutional morality? And Dr. Ambedkar said, constitutional morality is not a natural sentiment. It has to be cultivated. Because today Indians are more religious. Today Indians are more divided as well. So there is division in the society based on caste. That is why Dr. Ambedkar, he was against giving powers to the Panchayati Raj institutions, because he thought that these Panchayati Raj institutions, these villages, these are the dens of casteism. And if we give political power to these villages, they are further going to perpetuate casteism in the society. So he was against giving political power to the Panchayati Raj institutions, because he said democracy in India is only a top dressing on the Indian soil, and this Indian soil is essentially undemocratic. So if we have to teach people constitutional morality, it is a project. It is not natural. It has to be cultivated, because people still believe in Manu Simriti. People will still believe in their particular religion or their particular caste. So to make people understand that you should abide by the constitutional morality, it has to be a long drawn project. It has to be cultivated. Sai Deepak disagrees, saying it is this norm of this Western inspired constitution which imbibes its own values over us, where our values are different, rooted in Bharatiya, rooted in our civilizational ethos. He is particularly against the concept enshrined in the Constitution, secularism, socialism. Because whether you agree or not, our constitution or our democracy tries in one way or the other to build something of a civic religion. Every religion has its book, has its identity, has its own ethos. But in a democracy, should we follow religion? Or can we say our religion is the nation? Our holy book is the Constitution. Our holy flag is the flag of India, rather than of individual religions. So the project in West is to create a civic religion where they believe in the state, they believe in the nation, they believe in the country. They believe in the book of that country, which is the constitution. They believe in the flag of that country, which is different from their religious flags. Sai Deepak argues that no matter how much you want to create and establish a civic religion in India, Indians are identifying themselves from this perspective of religion, language, culture, civilization. Despite globalization, Indians are still identifying themselves along these markers of religion, of language, of caste, of civilization. And that is why some British experts would also say Indians are deeply religious in the same manner as the Europeans are secular. Sai Deepak argues that what is this Indian constitution? It's basically a bag of borrowings. We have borrowed provisions from different parts of the country. So where is the significance of our culture? Where is the push of our culture? Where is the inspiration from our culture in the constitution? That has been disregarded, and we have embraced the ideas from different constitutions of the world. That is my problem with the constitution. On top of that, the Western concept of secularism, the Western concept of socialism, although it's not a Western concept in any case. Sai Deepak writes that it would help to bear in mind that the presence of constitution has not prevented coups in our neighborhood. Despite the constitution in Pakistan, it is run by the military junta, by the military, by the army. So that is why we say in India, state has the army, in Pakistan, army has the state. Look at the condition of minorities in Pakistan. Look at the conditions of minorities in Bangladesh. Although during the period of Sheikh Hasina, the minorities were treated with respect, no discrimination. But after she is gone, look at the condition of the minorities in Bangladesh. So if India is secular, it is because 80% of the people in India are Hindus. If India is secular, if Indian constitution is respected, it is because our civilizational ethos tells us that we should respect our institutions. If India is still a vibrant democracy, it is because our very innate dharmic barometer tells us that we have to preserve the pluralistic fabric of India and we have to respect its constitutional values. Mr. Faizan Mustafa disagrees. He says in 1966, M.S. Golwalkar, who was the head of the RSS, he said the Indian constitution had absolutely nothing that can be called ours because we are blindly aping the West. Fast forward 2022, at an event, at a speech titled Hindutva and National Integration, RSS chief, he's saying Hindutva is nothing but a true reflection of the Indian constitution. So just like Indian constitution has evolved, what was Indian constitution in 1950 is not the Indian constitution in 2024 because 106 amendments have taken place. Constitution has to be a living document. It has to breathe through its different aspirations. In the same fashion, RSS has also evolved from the time when it would say that there is nothing Indian about the constitution to now saying Hindutva is nothing but the true reflection of Indian constitution. Faizan Mustafa argues that when Objectives Resolution was introduced by Pandit Nehru in the Constituent Assembly, and it was adopted by the Constituent Assembly on the 22nd of January 1947. While introducing this Objectives Resolution, because you would know Objectives Resolution later on became the preamble of the Constitution. While introducing this Objectives Resolution, Pandit Nehru spoke of the legacy of 5,000 years of civilization. So civilization was mentioned multiple times in Constituent Assembly. So Constituent Assembly did look into our civilization. Yet at the same time, Constituent Assembly also looked at the divisions within the society. Is it not true, according to Faizan Mustafa, that the Indian society was divided along the lines of caste. And there were caste atrocities committed, particularly after the later Vedic period. Does that mean Indian constitution should have turned a closed eye, blind eye into the caste-based atrocities and should have upheld those notions of purity and pollution and should not have implemented constitutional morality to abolish untouchability? It looked back, it looked at the civilization, yet constitution looked forward. Because what is civilization? If you ask the tribals, for example, Jaspal Singh, who was representing Adivasis in the Constituent Assembly, he said Adivasis are the original inhabitants of India. Aryans are intruders. So this civilization that you're calling, is it Aryan civilization, which is at odds with the original inhabitants of India, who are the Adivasis? These are not my words again. These are the words of Faizan Mustafa. The speech is given by Jaspal Singh in the Constituent Assembly. Hold them accountable, not me. I'm not guilty here. I plead innocent. Yet, yes, we have embraced various provisions from different constitutions of the world. That speaks volumes about the openness of the Constituent Assembly. They were not bogged down by the cultural baggage that we had. Yet they looked outside for inspiration, and that inspiration we then modified for Indian context. Because if we adopted parliamentary democracy from Britain, but we did not embrace monarchy, we embraced constitutional republic where the head of the state is an elected, not a hereditary monarch. So we embraced something from the West, but we modeled it along Indian traditions. Although we borrowed fundamental rights from US, but do you know that in United States, if there are restrictions to be imposed on the fundamental rights, those restrictions can evolve only through judiciary. Only judiciary can impose restrictions. But in India, if there are reasonable restrictions to be imposed on fundamental rights, who can impose these reasonable restrictions? Parliament. And the Constitution itself spoke of reasonable restrictions. Faizan Mustafa says, we disagreed with and we rejected the American model of due process of law because we embraced the Japanese concept of procedure established by law. Although later on, you would know in Maneka Gandhi versus Union of India 1978, Supreme Court said we follow due process of law. And apart from due process of law, we also follow principles of natural justice. Unlike other federations, governors are nominated by the center. Governors are not elected by the states because that's a departure from federalism. Otherwise, governors should have been elected by the people of that state itself. And we also speak about separation of powers between the executive and the judiciary. Faizan Mustafa argues, is it not this separation of powers which we can call in our civilization as Lakshman Rekha? Are these ideals of the separation of powers not basically what Indian civilization believes in Lakshman Rekha? And Faizan Mustafa argues that if we believe in Indian civilization, look at the point, that we believe in Vasudeva Kutumbakam, which is world is the family, and if the entire world is the family, we are entitled to borrow ideas, adopt ideas from anywhere. And if Sai Deepak, your problem is with that we have borrowed provisions from other constitutions of the world, Rig Ved talks about Ana Bradaho Kratavu Yantu Vishwataha. Let the noble thoughts come from all sides. And if we have adopted noble ideals from different parts of the world, it is basically civilizational. Because we believe in Vasudeva Kutumbakam. This completes the argument of both Sai Deepak as in Faizan Mustafa. But look at the question which was asked in Mains 2021. Constitutional morality is rooted in the Constitution itself. and is founded on its essential facets. What are the essential facets of constitutional morality? Liberty, equality, justice, rule of law. So every organ of the state has to abide by these philosophies, not the philosophy or the morality of the majority. Explain the doctrine of constitutional morality with the help of relevant judicial decisions. Constitutional morality was invoked in Sabarimala case as well, where Supreme Court said, 4 judges of the Supreme Court said, if you're denying entry to women of menstruating age inside the sacred sanctum sanctorum of the Sabarimala temple, you are basically blinking at the constitution. You are basically patronizing patriarchy. And that is something which is not at sync, which is at odds with constitutional morality. That completes our topic number 2. Okay, any questions as of now? Anybody? Vanshika, congratulations for your mains. All the best for your interview. Let's look at third topic, Sambhal's Jama Masjid. What was the issue? We have discussed that in the previous UCAN session, but very briefly, let me summarize it for you. Ayodhya, Ram Temple, Babri Masjid. There was a dispute. It was basically a civil case as to who is the legitimate owner of the 2.77 acres of land at Ayodhya. Argument was that this Babri Masjid was constructed by Mir Baqi, who was an important general of Babur, Mughal emperor, in 1528, after destroying the Ram temple. In fact, when Mughals came to India, at that time, many mosques were also constructed. At the time of Babur, only 3 mosques have survived in modern India. That means of all the mosques which were constructed during the Emperor Babur's reign, tenure, only 3 of them have survived. One such mosque is Sambhal's Jama Masjid. The other mosque was Babri Masjid, which was demolished in 1992 by the Kar Sevaks. And the third one is the mosque, the Kabili Bagh Mosque in Panipat, which was constructed when Ibrahim Lodi was defeated. This can be part of your art and culture, maybe can be asked in the examination. Not just Babri Masjid, Ayodhya Ram Temple, there were other places also where there was this dispute as to whether this place where there is a mosque, whether previously there was a temple on this place, whether this mosque was constructed after demolishing a temple. Because are there some proofs in our history that some temples, whether Buddhist, Jain, Hindu temples, were demolished and then mosques were created? Yes, there have been proofs as well. It has been recorded in the history as well. There are various farmans of Aurangzeb mentioned in various travelogues written by foreign travelers who came to India. But today in independent India, can we go back to the ghosts of the past and rectify the misdoings of the past in today's India? We saw what happened after Babri Masjid was demolished. There were communal riots in different parts of the country. This is where Parliament got together and enacted a law in 1991 called Places of Worship Special Provisions Act 1991. In fact, an article was written by P. Chidambaram in the Indian Express recently, wherein he said that this is one of the crispiest laws ever enacted in India. Because what is the objective? It is mentioned in few sections, that's it, and the law is over. And what is this law? It provides for the maintenance of the character of a religious place. So what was the character of a religious place on the 15th of August 1947 when India became independent? If it was a mosque, we have to maintain the character of that mosque. And we can't convert, it prohibits and criminalizes the conversion of that place of worship. You can't do that as well. You have to maintain the character of that place of worship, and you have to prevent the conversion of that place of worship to another denomination, to another community. This was the single objective of this law. But since Ayodhya, Ram Temple, Babri Masjid, it was already a dispute before the court, this Ayodhya Ram Temple was excluded from the purview of the Places of Worship Act. Because if this law would have been implemented for this 2.77 acres of disputed land as well, then on 15th of August 1947, it was a Babri Masjid. And this character should have been maintained, and you cannot convert the character of that place of worship. But since this was a case already in the court, it was excluded. But all other disputes will now cease to exist. In fact, you can't even file a case asking what you asked in case of Ayodhya Ram Temple, that this was a place of Lord Ram, this was where there was a temple, and now we need this land back. Such a case cannot be filed at all. In fact, when 5 judges of the Supreme Court in 2019 gave Ayodhya judgment, the Supreme Court spent a lot of time and ink on the significance of the Places of Worship Act, saying that it maintains the secular identity of India, because the ghosts of the past cannot be resurrected in the future. And in fact, the court upheld the secular identity of India and said this Places of Worship Act plays a very important role in ensuring secularism in India, rule of law in India. But after that, there were still some cases which were filed. For example, Gyan Vyapi in Varanasi, where the petitioners approached the local court saying this Gyan Vyapi mosque has been constructed on the ruins of the Shiva temple. So we need to worship our temple, because worshipping our temple is a fundamental right under Article 25 of the Constitution. And the local court ordered the survey by Archaeological Survey of India to verify these claims, whether such a temple existed at Gyan Vyapi Mosque or not. Similar cases were filed in case of Shahi Eidgah at Mathura, which was considered to be the birthplace of Lord Krishna. And now similar complaints have been filed against the Sambhal Masjid in Sambhal Jama Masjid, where it was argued that it was previously a temple. Although such cases should not have been filed according to the law, according to the Places of the Worship Act 1991, because no case can be filed. But yet the local courts ordered the Archaeological Survey of India's surveys. Matter went to the Supreme Court. The then Chief Justice was Justice Chandrachud, and Justice Chandrachud made an extraordinary oral observation. He said, although 1991 law bars the conversion of a place of worship, calls for the maintenance of the character of a place of worship, but what it does not bar is the ascertainment of what was the character of this place of worship. This is what constitutional experts say. It opened the floodgates, and now various petitions will be filed because of this observation made by Justice Chandrachud. Because if you want to ascertain the identity, the character of that place of worship, what are you going to do with that identity? The law prohibits you to convert that place of worship. The law provides that this place of worship's character has to be maintained. So what are you going to do by ascertaining? And now a 3-judge bench of the Supreme Court has been constituted by the Chief Justice of India, Justice Sanjeev Khanna, to review this Places of Worship Act, because a petition has been filed challenging the validity of this 1991 law. On what grounds? On the grounds that it violates judicial review, which is part of the basic structure of the Constitution, because 1991 law says no suit can be filed. on the grounds that it is arbitrary. Because how have you arbitrarily selected this date, 15th of August 1947, and you have frozen the character of a religious institution, of a religious place of worship as it existed on 15th of August 1947. Third, it also violates Article 25 of the Constitution, which gives me the fundamental right to profess, practice and propagate my religion. I want to practice my religion by worshipping a temple or the deity at a temple. So if it is a mosque now, it used to be my temple previously, I want to claim my fundamental right again. But whether this law is violative of all these accusations and allegations, that is for the 3-judge bench of the Supreme Court to decide. But what about this Sambhal Masjid? The local court in Sambhal allowed Archaeological Survey of India to survey this masjid to see whether there are some remains of the temple so that we can ascertain the religious character of this place of worship. And the Muslim side argues that this order was given ex parte, without hearing us. It violates principles of natural justice because nobody shall be prosecuted or sentenced without being heard. You can't give an ex parte order. So if our side has not been heard, then this is a matter which concerns violation of the principles of natural justice. And the Muslim side approached the Supreme Court. Supreme Court said, this local court shall not proceed further unless and until this Muslim side approaches the High Court on the grounds that you are challenging this ex parte verdict. So Supreme Court has not barred, contrary to the popular perception that such cases cannot be filed. What Supreme Court has asked is that the mosque committee can approach the High Court until the time High Court decides this local court in Sambhal should not proceed further, should not take any action. Keep that in mind. That is the update. Apart from that, a 3-judge bench has been constituted by the Supreme Court Chief Justice to review the validity of this Places of Worship Act 1991. Clear? In Turkey, the law says of recovering those places of worship that in existence before being taken over by other religion. That's how Hagia Sophia was also quote-unquote recovered and its character was changed. But now that's what the Supreme Court has to decide. Okay. Another topic, is the caste census a useful exercise? We have discussed caste census previously multiple times in our UCAN sessions. And there we have highlighted the significance, the importance of caste census, arguing that there should be a caste census. The crux of this article says that the idea of caste census is impractical. It is impractical to implement this. Even if you go for caste census, what is the purpose of caste census? Rahul Gandhi says, Jitni abadi utna hak, proportionate representation. So what is the population of a particular caste? In proportion to that population, they should get reservation in government jobs and educational institutions. That's the idea of the caste census. But this article says implementation of this caste census is impractical. Why? Let's go back in time. When the census was carried for the first time in 1872, although it was a non-synchronous census, it was not carried out together in different parts in the entire country. But the first synchronous census exercise was carried out throughout the country in 1881. And since then, it has been a decadal exercise. Every 10 years, census exercise has been carried out, barring 2021, which was delayed because of census. Now, there is a hope that in 2025, census exercise would be carried out. But be that as it may, subsequently after that, till 1931, whenever census was carried out, the enumerators, because in census exercise, people come, officials come at your door, ask you what is your name, what is your date of birth, what is your age, what is your mother tongue, what is your educational qualification, what is your economic criteria, what is your caste, whether you belong to SC or ST. That is asked even today. Your caste was also asked in these surveys, in these exercises, till 1931. But when the census was carried out in 1941, caste data was not captured. Why? Because at that time, it was the period of Second World War. The government was focused on winning this war. That means all the resources were channelized towards the war effort. And it would have resulted in extra expenditure. If we would have another column asking for caste, it would consume a lot of resources. That is why this caste data was not captured in the census of 1941. But after the enactment of the Constitution, since 1951, we have been capturing SC-ST data, whether you are an SC, whether you are an ST, but not about other castes. Now the argument is that there should be a caste census. Karnataka says there should be, Tamil Nadu says there should be, Jharkhand says there should be, Telangana says there should be, Bihar did a caste survey, although you can't call it caste census because census is under the union list. It is under the domain of the center, not with the state. So they carried out caste survey. And the argument is, by having this caste census conducted, we will have an idea about what is the exact proportion of each and every caste, so that then we can understand what is the backwardness of a particular caste, and accordingly we can provide them proportionate reservation in government jobs and educational institutions. But this can be a challenging exercise according to this article. Why? Because caste is a sensitive issue in India. Although we say that people don't cast their vote, they vote their caste. But if you ask somebody what is your caste, some of them may feel offended. Why did you ask that question? So if I am an enumerator, if I am a census official, I will come to you. I will not ask you your caste, maybe, because you may get offended by this. But I will ask your name. And whatever surname you provide me, on that basis, I assume what is your caste. Now, what if you say your name is A. Sen? Is it Sen or Sen? If it is SEN, then it's an upper caste Brahmin in Bengal. If it is Sen, then it is an OBC barber community. So when you are saying I am A. Sen, the enumerator will have the liberty to assume whether it is SEN or whether it is SAIN, which basically means that there will be errors as well. On top of that, if we look at, for example, Rajasthan, there are surnames such as Danak, Dankia, Danuk. They are classified as SCs. But if it is Danka, it is listed as ST. So when as an enumerator I will approach you, you will say Dankia, Danuk, whatever. I may misunderstand it, which means there will be misclassification as well. On top of that, the year was 2011 when socio-economic caste census was carried out. But please understand, it was a different exercise. Normally, census is conducted under the Ministry of Home Affairs by the Registrar General and the Census Commissioner, under the Census Act of 1948, under the Census Rules of 1990, because these are trained officials coordinating, conducting, carrying out census exercise under MHA, Ministry of Home Affairs. But the socio-economic caste census, it was carried out by Ministry of Rural Development in rural areas, by the Ministry of Urban Development in the urban areas. And these departments, these ministries do not have the expertise of carrying out census. That expertise is with the Home Ministry. And that is why we saw errors. Errors in the sense, although what is the final report of the socio-economic caste census, we don't know. But some data is provided. Some data in the form that when this socio-economic caste census was carried out, it identified 46.7 lakh caste and subcastes in India. 46.7 lakh caste and subcastes. And out of that, we saw that there were 8.2 crore errors, because you don't have expertise in carrying out census. That expertise is with the Home Ministry. So there will be errors when you conduct such an exercise. On top of that, the controversy in Bihar. When Bihar carried out caste census, or caste survey as they call it, they said Hijra is a caste. It was recognized as a caste. But you may be a Hijra from a Dalit community, from a Brahmin community, from a Rajput community, from another community, from another religion. How can Hijra be viewed as a caste? It is not a caste. It may be your sexual orientation. Such problems will creep if this caste census exercise is carried out. And on top of that, if you are trying to give proportionate representation, proportionate reservation to individual castes, it would be a nightmare, according to this article. Why? We have 27% reservation in for OBCs. We have 15% reservation for SCs. We have 7.5% reservation for STs. Right or wrong? How are these seats reserved when it comes to government jobs? 100 divided by 27 for OBCs. 100 divided by 27 means 3 point something. And if you round it off, rounding off, it would mean 4. That means every fourth vacancy will be for OBC. 100 divided by what is the percentage of reservation provided to you? If it is 27 for OBCs, 100 divided by 27, rounding off, it means 4. That means every fourth vacancy will go to OBC. Similarly, 100 divided by 15, which means 6.7 onwards, let's say round off 7. That means every 7th vacancy will go to SC. 100 divided by 7.5, roughly 13 point something. So rounding off it, it means 14. That means every 14th vacancy will be for the ST. This is how vacancies are, this is how reservation is provided. Now imagine, we don't have only 3 groups, SCs, STs, OBCs. We have another group, which is EWS. 100, what is the percentage of reservation for EWS? 10%. 100 divided by 10, which means every 10th vacancy will go to EWS. But these are 4 blocks that we have. What if we further deep dive into it and provide it for every caste? How many castes do we have? Socio-economic caste census says we have 46.7 lakh castes. And then we have to look at the individual population of that caste. Let's assume that there is one small caste and its population is, let's say, 10,000. 10,000 is the population of that caste. Basis this logic, for this caste to secure a reservation, 100 divided by what is the number of reservation? If we just take UPSC's example, because UPSC every year releases almost 1,000 vacancies for civil services examination. That means every 4th will be a OBC, every 10th will be EWS, every 14th will be ST, every 7th will be SC. Then by that logic, if this smallest caste group, which has a 10,000 population, then by that logic, UPSC should announce close to 1,40,845 positions, and only then this smaller caste group will get one reserved seat. By this logic, if we consider that we have 46.7 lakh castes, by this logic, UPSC should release 46,73,034 vacancies only then this caste will get reservation one vacancy, which means it will take 7,000 years for this caste group to get one reserved seat in UPSC. So although on paper it looks like caste census is a good exercise, because we can get to know what is the population of an individual caste and whether they are represented in the administration or not, and accordingly we can provide them reservation. But when we dig deeper, it will be a nightmare to implement this, and it would be impractical because we follow these calculations in assigning vacancies. That is why this article says, is the caste census a useful exercise? These numbers can be used to give an idea about different castes, but to call for proportionate reservation. That means in proportion to your population, you should get the reservation. What about these smaller castes which have 10,000 population or less than that population? It will take 7,000 years for them to get reservation, to get vacancy for them in UPSC. And that too, if UPSC announces 46 lakh odd vacancies. That is why this idea of caste census, one argument is it is impractical. Clear? Let's look at another beautiful article. Indira Sani versus Union of India, 1992, Apex Court advocated reservation should not breach 50% limit. But Supreme Court said in extraordinary circumstances, you can breach this limit as well. But Supreme Court further said in Janhit Abhiyan versus Union of India, this was the case where Supreme Court upheld the EWS reservation. Supreme Court said this 50% cap applies to SC, ST, OBC reservation. It does not apply if a new category is created, such as EWS. Okay, now let's look at two new schemes ahead of elections amount to voter bribes. Look at the performance of the Jharkhand Mukti Morcha in the recently concluded elections in Jharkhand. It is argued that because there were some schemes specifically targeted at women, JMM Congress RJD alliance was in a position to return to power in Jharkhand. Ditto in case of Maharashtra, because just before elections, a scheme targeted at women was launched by the Deputy Chief Minister, by the government, and it is this scheme which provided impetus to the ruling coalition, and they won with a thumping majority. And that scheme, which was Mukhyamantri Maji Ladki Bahin Yojana, it was not something new. It is something imitation of Shivraj Singh Chauhan's scheme, which he implemented in Madhya Pradesh, Ladli Bahin Yojana. So this scheme was conceptualized in Madhya Pradesh, but then imported to Maharashtra, and now there is competing populism which takes place. In Karnataka, Congress also announced 5 guarantees, and 2 of these guarantees were specifically targeted at women. Now all the political parties, they're competing with each other to have specific policies for women in the form of cash transfers, because these schemes are nothing but cash transfers. Every woman in a household will get a cash transfer, whether it is 1,500 or 2,100, whatever. The question asked in this article is, does this amount to voter bribe? Because bribery is an offense. And if such schemes are announced just before the elections, can we say that these schemes are bribing the voters and as such corrupt practices under the Bharatiya Nyaya Sanhita, under the previous erstwhile Indian Penal Code? This is where 2 fantastic individuals, Ritika Khera and Vikas Rawal, they are in a debate. Vikas Rawal, professor at JNU, he says that it is problematic when you announce it just before the elections. Because if these cash transfers lead to welfare, then we can say okay. But if it doesn't lead to welfare, it is just cash transfer, then we have a problem, because after that it has an impact on the fiscal burden on the state. Ritika Khera, she disagrees. She says this is not the problem, this is not the practice which started now. In Tamil Nadu, both the Dravidian political parties, DMK as well as AIDMK, they have been in competition with each other for providing some benefits to women. For example, they would say that we will provide juicer, mixer, grinder to women. Some would say they will provide color television sets to women. Matter went to the court. A case, if I can remember the case name correctly, Subramanyam Balaji. In this case, in 2013, Supreme Court said, these may be freebies, but freebies, they shake the heart and root of the free and fair elections. But the argument raised by Ritika Khera is, then what about the election manifesto of political parties? Election manifesto providing that if you vote us to power, we will give you juicer, mixer, grinder, color television sets. Does that also not amount to bribery and bribing the voters? Why do you have specific problem with the cash transfers to the women just before the elections? The government in Tamil Nadu justified these color television sets and juicer, mixer, grinder on the grounds that it is empowering the women. Because women who take care of the household activities, once they are done, the only means of entertainment for them is a color television set. And through color television set, they may not only be watching the soap opera of Balaji telefilms, of Shobha and Ekta Kapoor. They would also be watching the political speeches by political parties. They may be watching the proceedings of the Lok Sabha and the Rajya Sabha and the state assemblies, through which they will get political education. And even if they use it for Big Boss or soap opera, it is for their entertainment. Because after all, she is doing a hard work at home. So how is this a freebie? And how does it shake the root and heart of free and fair election? But Ritika Khera makes a very important point. She says, my problem is not with the cash transfer. My issue is, what are we trying to achieve? What are we trying to achieve? Are we trying to achieve financial independence of women? That women should be financially independent, that is why we are giving them cash transfer. Are we giving them this money so that they can spend on health and nutrition? Or are we giving them this money to compensate them for domestic work? Because if you ask government is saying we have these Ladli Behan or various other schemes targeted at women. This is to give them financial independence so that they are not dependent on others. They are not dependent on their men, whether husband or father or a brother. So to give them financial independence, we need cash transfers for women. The idea is that if you give cash in the hands of the woman and cash in the hands of a man, man will spend it on liquor, on gambling, but women will spend it on education, on health, on nutrition of the kids and herself, including the man. So she will spend it for better, reasonable purposes than a man. So for health and nutrition, we are providing her cash transfers. And we are providing her cash transfers according to the government because we want to compensate for the domestic work that women is doing. Because let's understand, what is GDP? The monetary value of goods and services produced in an economy. Women also contribute in the form of domestic work, but that is not contributed that does not get included in the GDP because you don't put a monetary tag to it. It is for these reasons that we provide cash transfers to the women. But Ritika Khera disagrees. She says if it is for financial independence, better what is the better alternative? Is it cash transfer? Or is it employment? Of all the women she has spoken to, these women tell her that we need employment rather than cash transfer. And if employment is to be provided, for that we have MG Narega, Mahatma Gandhi National Rural Employment Guarantee Act. Then why is the central government not increasing and enhancing the budget for MG Narega and instead providing cash transfers? If we look at Tamil Nadu, for example, women get cash transfer of 12,000 rupees in a year. Cash transfer, 12,000 rupees a year. But if she gets 100 days of employment every year, which is her statutory right under MG Narega, the amount of money that she will get is 29,000, which is more than double of this cash transfer. So if you are giving this cash transfer to make women financially independent, don't give cash transfer, instead give employment. Instead enhance the budget for MG Narega. Second, if you are giving cash transfer to enhance the health and nutritional capability of a woman, why do you stop providing eggs to children in the schools, in midday meals? What about enhancing the nutritious food and providing it to the women and children? And if you are providing this money to compensate for her domestic work, you are basically indoctrinating patriarchy into the minds of the people, because of this argument, you are telling the people that domestic work is the sole domain of a woman and a man has no role in participating in the domestic chores and the domestic work. So you are normalizing this behavior in the society that women are there to take care of the take care of the kitchen. So these three arguments, I don't have problem with cash transfers. I have the problem with what are we going to achieve through these cash transfers. That is the central point of this beautiful conversation. Do new schemes ahead of elections amount to voter bribes? Then this is the cover story of the last edition of the Frontline. No vote bank, but an optical illusion. Prime Minister Modi, in one of his campaigns, in one election, he spoke at a gathering which included only women. And in fact, he said that I don't believe in 4 castes, the Chaturvarna system. For me, 4 castes are poor, youth, farmers, women. Women as a distinct vote bank is being cultivated by various political parties. For example, Nitish Kumar in Bihar, Mamata Banerjee in West Bengal, Arvind Kejriwal in Delhi, in Karnataka, Siddaramaiah. It was viewed as a vote bank by KCR in Telangana as well. But whether women's participation has increased and whether women's representation has increased. 73rd and 74th Amendment. What these 2 amendments did? They provided political reservation for women. Not less than 1/3 of the seats in Panchayati Raj institutions and urban local bodies shall be reserved for women. Not less than 1/3. Can it be more than 1/3? Yes. Are there states which provide 50% reservation to women in Panchayati Raj institutions and urban local bodies? Yes. So what we saw After the 73rd and 74th Amendment, conversations about women's political representation and political participation. And in fact, over a period of time, we have seen it manifest into different forms. Different forms in the sense, now there are women voters who outnumber men. As I was telling you in the first article itself, that there was a gender gap. What was this gender gap? If there were 100 voters, 60 would be men, 40 would be women at the time of the commencement of the Constitution. And over a period of time, because of various initiatives of the Election Commission of India, also because today's women, they are not only considered as voters, they are considered labarthis, the beneficiaries of these schemes, because we openly say that this is for women beneficiaries. Have these schemes resulted in active women's participation in electoral politics? In a sense, now this gender gap in the election has been eliminated. Equal number of men and women, they throng the polling booths. So today's women are suddenly visible, both as voters as well as labarthis, as beneficiaries of various welfare schemes. But the Frontline tries to dig deeper to understand whether this is reality or it is an illusion. Whether women have been made into a vote bank or whether it is only an optical illusion. In 1996 elections, the gender gap between men and women in terms of voters was 10%. In 2024, negligible. On top of that, we are now talking about a phenomena called arrival of woman. Ladki Bahin, Ladli Behna Yojana, whether Madhya Pradesh, Maharashtra, it has viewed women as beneficiaries, and now these women are coming out in large numbers and voting. But is that leading to women's participation or representation? Participation or representation in the sense, if women voters are outnumbering men in 19 states in India, but what do we know about women's representation in the legislatures and parliament? Look at Madhya Pradesh. Madhya Pradesh now has 27 women MLAs, more than 10% of the assembly, and this has happened for the first time. Is it the impact of the schemes targeted at women, because of which they come out in large numbers and their political representation has also increased? In Jharkhand, the number of women MLAs has risen from 3. It was 3 in 2000, now it is 12. Trinamool Congress, it has 11 women MPs. That means 38% of its total strength in the parliament is made up of women. In Madhya Pradesh election, however, of 2,716 candidates who contested elections, only 253 were women. In Maharashtra, only 363 were women. If women are viewed as a vote bank, why are political parties still reluctant in giving them tickets to contest elections? If women have finally arrived, why is there lesser participation of women in the labor force? So that is why we can say it is an optical illusion. There is still discrimination against women, despite the fact that women-centric policies have been created, conceptualized. But this is like, listen to me carefully, undemocratic paternalism. Undemocratic paternalism means we will consider you good enough only for a beneficiary, not as an equal partner in power sharing. We will still give you less number of tickets. We will still not let you contest elections, but we will view you only as labarthis, the beneficiaries. That means this notion that women vote bank has been developed. There is no empirical data to suggest that such a thing exists. And in the absence of a robust empirical data, we can best say that this is conjecture. What is a conjecture? If you are watching, if you have been watching Coffee with Karan Johar would use this term frequently. This is based on conjecture. This is a rumor based on conjecture. Opinion that you form on the basis of incomplete information. So if you're forming an opinion that woman vote bank has finally arrived, it is based on incomplete information. It's a conjecture. Why? Because there is no robust empirical data to suggest that such a thing exists. Because there is a paradox. Paradox in the form of that if women voter percentage has increased, why is there declining women's participation in the labor force? Why political parties are reluctant to give them tickets? Why there is less political representation for them? And even with this, we say women, they are beneficiaries of schemes. They are not autonomous political agents. Because it remains to be seen whether these women are voting for political parties because they get money in the form of cash transfers, or does caste still play an important role? That these women will still vote on the basis of caste lines, or it remains to be seen whether these women still vote based on the preference of the men in the family and the men dictate political choices of the women, or are they really autonomous political agents? For that, we need a robust empirical data. And without that robust empirical data, we cannot come to a solid conclusion. The only data at the national level that we have is the one conducted by CSDS, Center for the Society of Developing Societies. But even that data does not point out to this illusion that there is a woman vote bank. And this topic, by the way, can play a very important role in your GS paper 1 as well, the Society of India, whether the woman vote bank has finally arrived. And you can cite the statistics that I provided in this session. Let's look at the question. The larger trend of increased participation of women in electoral politics signals a new democratic upsurge, which will shift the political discourse from being male-dominated to being more equitable. Comment. So will this push for greater schemes for women and the increased voter participation by women, will it lead to a shift, because politics is still considered to be a male-dominated bastion? And will there be a different shift in this bastion? And will our politics become more equitable? We will have to wait and watch. That is it about today. If you have liked this session, liked in the sense, if you have understood whatever we discussed in this session today, please let me know in the comment section after the live session is over. And do not forget to press the like button and subscribe to our channel if you haven't yet. As I announced in my Telegram channel, if you want the PDF of this lecture, that shall be made available on my Telegram channel. The link is provided in the comment section, in the video description. And right from 9:45 onwards, I would be taking questions specifically from our Unacademy students, because they complained a lot that you're having these sessions on YouTube despite the fact that we paid for these sessions. This is discrimination towards them. And today, to resolve that discrimination, let me quickly address all the doubts of the students. If you have any doubts, please let me know. Sir, can you cover all important commissions and judgments important for the exam? We'll do that just before the prelims. We will launch Conquered Prelims on YouTube, where we will cover all the important current affairs topics, MCQ wise, in these sessions. Is the police authorized to take action against the incident that took place during the break during the proceedings of the hall? Which hall are you talking about? The parliamentary hall? If something happened outside the parliament, yes, the police is within its power. If something happened within the parliament, and if the speaker has given the permission, then police can investigate. What is electoral bond? It was a scheme wherein if you want to donate money to a political party, you have to buy a bond from State Bank of India worth 1,000 rupee, 10,000 rupee, 1 lakh rupee, 10 lakh rupee, 1 crore rupee. And that bond you can deposit in the bank account of a political party. And the political party will encash it. But this bond you can buy only in the form of a check or digital transaction. You cannot buy it through cash. But this bond is anonymous or was anonymous. That means nobody will come to know who is donating money to a political party. Since this entire scheme was based on anonymity, the Supreme Court struck it down. For answer writing practice, do we practice previous year's questions or current affairs based? Both. Isn't in presidential system collective decision making? That is a feature of parliamentary form of government. In presidential form of government, the powers are concentrated in the hands of the executive, the political executive, the president. Alimony, dowry related, make a video. There is already a video available on the unfortunate incident of Atul Subhash. You can watch that video on our YouTube channel. Where do we draw the line between RTI and right to privacy of candidate? Very good question. But what will trump? Right of the voters to know about the candidate or the privacy of the candidate? And we are not talking about the intimate details about candidates. We only want to reveal the information that will help voters make an informed choice. For example, what is your educational qualification? How many assets do you have? And in the name of your spouse, how many criminal cases are pending against you? This information is necessary for a voter to make a choice whether the voter should vote for you or not. We are not asking your personal details about your relationship with your wife or the relationship with your kids or some intimate details about you. What is your medical condition? Such details which are intrinsic part of your privacy, you don't have to reveal. Any recent course on Unacademy? I have a Polity course ongoing for 2026 batch students. And for 2025 batch students, there is a course coming up on the 15th of January. Do you think, confirm what kind of place of worship a site which has indeed opened the floodgates of these cases being filed? How will the Supreme Court rule on this? Can you rephrase your question, please? A lot of things related to religion are happening. Please tell us how to write a neutral conclusion for it. For that, you have to ask me a specific question. For that, I will give you an answer. But whatever answer you write, that should be based on constitutional morality, rule of law, liberty, equality, justice. Do you think current political system should be abolished? Then how will you replace it with? And what will you replace it with? Okay, that is it for today. Thank you so much for staying with me. Hope to see you again with another edition of the UCAN towards the end of this month, where we will cover the remaining days of December. Thank you for watching. Stay safe. Good night.